Hi, this is Blaine Cluten for Cluten Law, answering the question about what happens if I'm married and I die and I don't have a will. So I'm going to link back to a previous video where I talk about intestate succession because this is going to be important about who your heirs are going to be. The second thing that I want to talk about is, in general, it's going to depend a little bit upon if you've done any sort of estate planning. And by that, I mean, if you've converted certain property to transfer on death or with rights of survivorship, then depending on what type of property is still left over, if it's personal property or real property, it may or may not be necessary to do a probate, that is a court process in order to transfer ownership and pay creditors at all. And then, depending on if it becomes necessary to transfer some of that property or pay creditors, the size of the probate in Oregon is either a small estate affidavit or a full-on probate. So a lot of these things are going to depend on whether there's been any sort of estate planning that's gone into effect before you pass away, and then after that, the amount of property that's at issue, and then creditors' issues. But generally speaking, what's going to happen if you pass away without a will is that your property is going to be probated. Now, I alluded to earlier the fact that things can have a right of survivorship. So for instance, the most common example and the one that most people are familiar with are DMV titles, car titles, truck titles, trailer titles. So you can designate a survivor on titles, and then in that sense, it doesn't need to go through a court proceeding in order to transfer the ownership. Another example of this would be with banking institutions or life insurance policies. You can designate a beneficiary. It's also sometimes called a transfer on death. And that money, you don't even have to name the person on your bank account. They don't have to become an account holder. You can simply designate them as a beneficiary. That money then passes to that other individual without the necessity of going through a formal court proceeding. Obviously, life insurance, you designate a beneficiary. These are things that most people are familiar with, but maybe most people don't know that you can do the same types of thing with almost all financial instruments. So practically, what ends up happening is, unless you have a lot of heirs spread out and you're needing to create some sort of formal instrument to make sure that that money is fairly evenly distributed, or you have a lot of creditors, or there's tax implications, or you have some sort of other real property that's probably going to need to be sold or otherwise devised, there are instances where if you die without a will, that perhaps nothing needs to happen as far as a probate. But all of this is going to be extremely fact specific, and it's going to ultimately also depend on creditors and if you're married or not, and then what other heirs are out there. So if you have specific questions about your particular circumstance, please do reach out to a estate planning attorney, or set up a consultation so you can for sure understand what's going to happen, and then ultimately probably end up setting up a will or some other estate plan, whether it's a trust or a mechanism in order to completely avoid probate. This is Blaine Cluten for Cluten Law. Thank you.